interesting times are going on. Okay. In all of that mess, there are n number of topics which have to be covered. Most of them very interesting ones. For example, special intensive revision after Bihar elections. Okay, special intensive revision after Bihar elections. Next is ammonium nitrate, the blast which happened in Jammu Kashmir and all the terror attacks. Then cheetahs are being transferred from Botswana again. The new golden blood. Okay, golden blood. Approximately 50%, only 50 individuals in the world have this blood, golden blood, very rare. Rest is the new Indo Army doctrine or striking doctrine, Rudra, cold strike. Deep state, very interesting topic. Deep state from Vietnam to Venezuela. How this deep state has changed geopolitics and is still paving the way or steering for geopolitics. What is the meaning of deep state? It has been seen since Vietnam and to the present day till Venezuela. Other is rare earth. The whole world is now fighting for it. There are countries which are governing others and asking options or like somewhat pressurizing them. America pressurizing Greenland to give up green earth. Then today's next topic is Gen Z. The Gen Zs and the Zen Alphas. But keeping all this in mind, what we'll discuss is this. Gubernatorial. Just sorry for the pronunciation. Gubernatorial. It's from the images it might be very clear. Okay. Gubernatorial means what? Relating to the governor. In the last 10 to 15 days, any articles if you've seen, this word was very much in news, so I just brought it up and used it as a theme. Gubernatorial meaning relating to the governor. Okay. Now this whole image represents very familiar image. You all know what is going on. But why are we discussing today? Because very rarely in Indian history, in Indian law history or Indian history of judgments, within a span of less than 6 months, Supreme Court has overruled or overturned its judgment within a span of 6 months. That is why we are discussing it. Okay? The whole idea is what the Supreme Court thinks, what the politics think, and what the Constitution has it. So we'll start. This is the real tussle. Okay, it's the tussle of federal versus state. The never-ending tussle, the unending tussle of the Indian Constitution, and the present players are the Chief Minister of Tamil Nadu and the Governor of Tamil Nadu. Okay? See, we all know the role that the Governor has. We'll discuss in detail. But this is the never-ending tussle, and it is form of what? Power structure. Okay? Everyone wants more power and their supremacy. And what happens in all of this? Where is democracy? Power to lead democracy. Okay. Brief introduction. Like, stats, data, or the constitutional validity of what is going on. How is the governor elected? If you are preparing for any exam, any government exam, very simple. Governor is elected indirectly, and so is the case of the president. There are presidential elections held, but those are indirect elections. You have to go in detail, but in simple, they are not mandated by the people. They are not mandated by the citizens directly. But in the case of Chief Minister, he is elected directly. You and me, common citizens, they vote for MLAs, and the MLAs decide who the Chief Minister will be. But it is a form of direct election. You are choosing your party, you are choosing your MLA, or in the center, you are choosing your MP. And the MPs in turn choose their Prime Minister, and the MLAs in the state in turn choose their Chief Minister. So it is a question of direct elections versus indirect elections. It is a question of power who is given, mandated by the people, and power which is not mandated by the people but given higher authority. Okay. How is this power distributed? Schedule 7 of the Indian Constitution. Schedule 7 of there are 4 lists, very easy to remember. Center list, state list, concurrent list, and the 4th, residuary powers. Not important. Whatever power the center holds, it's in the center's list. In the state's domains, it's the state list, and where both have to work in tandem, in coordination, it's the concurrent list. And the new things which haven't been codified as of yet and which haven't been thought as of yet, given the old times, new times, almost all the times, those things which haven't been thought as of now will be seen in the residuary list. For example, cyber tax. Okay, all those things come in the residual list. Not important for today's subject, but last is how does it work? Why are the legislatures? To make laws. Legislatures to make laws. Why do they make laws? To govern the whole society, to govern the whole country. That is how the working is. Now, we elect someone, they make laws. Okay? But for that law, for that bill to become an act, what do we need? What do they need? What does the constitution say? There must be approval by the governor in the state and by the president at the center. Now, this is the whole tussle. Okay. The people who are voted to power make laws, are trying to make laws in this case per se, but due to some reason or unsaid reason, okay, it is being subjected to delays, indefinite delays, delays for years. Now, what does that lead to? All this leads to the coming of the judiciary in the middle. Who will solve these cases? Judiciary. So, that is the whole tussle. See, understood the introduction? Now, you got the brief idea, right? That Tamil Nadu in 2022 itself, or 22/23 itself, it had passed 13 bills. 3 of them were made acts, but 10 of them were delayed for years, like delayed for indefinitely. So there, logical, intellectual, educated people might have think there might have been some reason, right? Some reason due to which the governor or the whole governor structure, governor machinery, all the intellectuals around him, for some reason he might have delayed those bills. Just keep that part in mind and understand the state at which Tamil Nadu stands today. What is the role of Tamil Nadu in India and what is the position at which it stands? If you see, Tamil Nadu is among the top 5 states in almost all the categories, and the data is given by Niti Aayog itself. Just countering the question, that means it is not a Bimaru state. It has never been a Bimaru state. The graph which it has is almost leading. Then, keeping all these factors in mind, why is the governor stalling the bills? Just, if you see, infant mortality rate, in India it is 28 and in Tamil Nadu it is less than half of India, it is approx 13. See, these are not important, just to get a general overview, the state at which Tamil Nadu stands today. Keeping that in mind, what is going on? Total fertility rate, India has 2.2 and Tamil Nadu is 1.8. Far better. In the same, if you see all these data, it simply shows that Tamil Nadu is almost on the top 5 to top 10 states of India, and since ages, since decades. The other data which is, we all are related to education, right? So education data is also here. Okay. Literacy rate 80%, India's average 73. Dropout rate is only 10% and class 10 pass rate is 97%. Just imagine the education. We all know Tamil Nadu and Kerala very educated places. Okay, nothing. What is economic data? Okay, all this you can see. Just pause and see it whenever you like. The whole point why I am trying to say is that Tamil Nadu on its own is doing well off. The machinery over there is doing good, in simple terms. Then why is the whole bills being delayed? That is the question. Okay. Now see, this is the fight. Herein comes the role of the governor. Okay. According to Article 200 and 201, you should memorize it. The governor has got what? 4 powers. Okay. Relating to any bill. Okay. Governor is what? Again, he is appointed by the center. He is appointed by the president. So he is a nominal head. Okay. And where does his loyalty lie? His loyalty lies towards the center, towards the president. Indirectly the ruling party of the center. That is where the loyalty lies. Now what does the 4 options he have? You will understand the whole topic in detail when you try to start connecting things. Very simple, if he gives his assent, like normal people do, normal governors do. If there is nothing extra clause added, like hota na, if some state is trying to divide itself from India, those clauses are trying to subdue the power of High Court. Okay? Then those are exceptional cases, but in rest of the cases he can easily give his assent. Second, this with marked withhold his assent, it is also known as pocket veto. The whole fight is because of this, we will see in detail. Okay? Second option that he has is withhold his assent. Withhold his assent means he will just be sitting on the bill will be sitting on his table indefinitely without any timeline. Remember the word timeline also. Third is he will return the bill to the state legislature. Okay? And if the state legislature returns the bill again to the governor, it will be deemed as passed, but he can return the bill. And last option is reserve the bill for the President of India. Okay. If you see, in all the three options, okay, in three of the above options, the bill does not become an act for sure. Okay. If he withholds it, if he sends it to the governor, to the president, the bill does not become an act. But why? The whole question over here is why. Okay. Why, after seeing all the data, the health data, the education data, the economics data, the people in Tamil Nadu itself, the legislature itself is doing a wonderful job compared to the rest of India. Then why are the bills being delayed? Most of the people answer it's a political question. So we don't discuss political debates over here. Okay. But for example, in the parliamentary debates of 1947, the question was asked about the powers of the governor and why does he need such a power. The only simple answer was like, if a state has separatist tendencies, if a state wants to come out of the Union of India, if a state passes such a bill, who will stop it? Therein comes the role of governor. It is the governor, he is the governor, he is the nominal head of the center to stop such a separatist tendency. That is where the role comes. But these bills are mostly education bills, health related bills. Then why are they being delayed? That is the question. See, it's a political fight. Just in one line, it's a political fight. To some extent, it's become an ego fight because most of the opposition ruled states have such an issue, but most of them solve it on the talking table, on the round tables. The chief ministers and his team and the governor and his team both sit down and they somehow try to find out a solution. But in this case, it has been dragged to the Supreme Court because there has been, the talking tables, the round tables has not worked out. That is the issue. I'm sure you all are fans. So what we'll start with is the flashback. What happened? To understand everything, you need a brief history. So this is, I'm just naming it the flashback. What happened is, on 13 November 2023, 10 bills were returned by the governor. Just remember, 13th November 2023, roughly 2 years previously, as of today's date. 10 bills were returned by the governor. What was the immediate action? The immediate action of the Tamil Nadu state government was they approached the Supreme Court. Now they went to the Supreme Court. What did Supreme Court do? On 2nd of April 2025, visible? Very much visible. Okay. On 2nd of April 2025, they gave out the judgment. The judgment was ruled by a divisional bench. Now you to understand this, these two other judges that gave the judgment, because in the next slide we will see the present judgment is very much in news and the 5 judges relating to it. The constitutional bench was very much in news. So we need to remember those 2 divisional bench judges also who gave the earlier judgment, which has now been overturned, which has now been overruled by the Supreme Court itself within a span of 6 months. Okay. So Tamil Nadu government approached the Supreme Court, and what happened? The simple case was that the governor has been sitting on the bills, on the files for years. Now what is the solution? The solution was, what these 2 gentlemen, honorable judges, said was, if such a delay has happened, if the governor is taking this long for him to pass the bill or just reject the bill, just act on the bill, then without consent, without assent of the governor, the bill will be deemed to become an act. That has never been in Indian history. Without the assent of the governor at the state level or the president at the national level, any bill cannot become an act. But the judgment said that without consent or without assent of the governor, the bill will become an act if it is being indefinitely delayed for any reason. Another thing which they said was, you'll just read these articles, they had said the timeline now. The whole fight was for what? I said the whole fight was for timeline. Time-bound manner. The bill should become an act or be rejected or be given to the president in a time-bound manner fashion. So what they said was, they gave a timeline of 1 month. So generous. They gave a timeline for 1 month to the governor that within a span of 1 month, you'll have to decide on the bills. All till that time it was okay. Must act with due deference to conventions of parliament democracy. Supreme Court says the Tamil Nadu governance reservation. You can just, when you've got time, these are important articles, go through them. Supreme Court holds Tamil Nadu governor's reservation of 10 bills for president assent is illegal. For president assent is illegal. Okay? That was the basic idea. Now what they said was they gave 1 month timeline to the governor. With that, they added what? They gave a 3-month timeline to the president itself. Imagine, for the first time, there have been very rare occurrences in which the Supreme Court is directing the roles and the powers of the president. Okay? In this whole scenario, the president is also involved because the bills were reserved for the president. Okay. Now the timeline, remember, 1 month for the governor and 3 months for the president. This led to what? This led to a national debate. Okay? What is important is this led, if the Supreme Court, if the divisional bench of the Supreme Court, okay, it's coming. If the divisional bench of the Supreme Court is itself giving directives for how the president to work, within which timeline the president has to work, that led to a national debate. And what was that debate? Okay? Remember this, president also and president also. Till the time it was for the governor, the debate was somewhat subdued. But as it reached to the president, it became a national debate. Now see, what is the debate all about? Okay. Is the Supreme Court this powerful to give the president timelines, and if not adhered to, judicial review? In simple, what the Supreme Court said was, the divisional bench said was that, you can see the names also of the gentlemen. Okay, not important. Honorable judges, that will do. That the debate started was, is the Supreme Court this powerful that it is prescribing timelines, time-bound manner, fashion for the president itself? And if the president or the governor is not working, is not adhering to these principles, there will be judicial review. This is the, is the Supreme Court this powerful? This is the debate which started. So what our Honorable President Draupadi Murmu ji, what she did was, she humbly, very genuinely asked 14 questions to the Supreme Court itself. It's within her powers, it's within her limits. Of course, everything is within her limits. That please guide us. Now you are setting timelines, so just enhance more. Throw more light on what is going on. So, President Governor don't have unbridled powers and can't exercise absolute veto on state bills. This is what the Supreme Court has said. Again, time bound or judicial review, give reasons for. If it is not, the bills are not passed within time, there will be judicial review also, and they will also have to give reasons for it is taking place. Again, don't have unbridled powers. Imagine the Supreme Court telling the president that they don't have unbridled powers and can't exercise absolute veto on state bills. Understood? This is what is going on. Now, what our president did was, and see, by president we meaning what the cabinet did. You'll read in the further chapters that whatever the president does, she or he does it on the aid and advice of the cabinet. Now see, this is the important slide. Okay. Please come back. Okay, it's here. What is not given, mentioned, documented, articulated in our constitution? The timeline has been not given in the constitution. Our constitution is a very detailed document. You might have most lengthy constitution in the world. In spite of that, the timeline was not mentioned. In simple, our president asked the Supreme Court that, are you telling us what to do, what not to do, what has not been involved in the constitution, what has not been properly said by the constitution? Is that what you are telling us now? So President Murmu seeks Supreme Court's opinion with 14 questions. These were the most beautiful articulated 14 questions. If you see the chronology, the first 4 is related to the governor. And first she asked the questions about the governor, and then the role of the president comes in. So you have to read this 14 questions to understand all these are related to this. The things which are not mentioned in the constitution, by every step, by every question, she is trying to analyze more, get more idea of what the Supreme Court is thinking regarding it. So let's read the questions one by one. What are the constitutional options before a governor when a bill is presented to him under Article 200? The governor had 4 options. But when the governor exercised these 4 options, there is a tussle. Most of the 3 options are in which the bill does not become act. So she's asking the same thing. The president is asking the same thing, that what are the constitutional options before a governor when a bill is presented to him under Article 200. Remember, this is a question of governor first. Second is again, if governor is bound by aid and advice tendered by the Council of Ministers while exercising all the options available with him when a bill is presented to him. like the president at the center is bound by the aid and advice of the cabinet. In the same manner, the governor. But if the governor is bound by it, then what options that he have except that? What are his discretionary powers? Third, is the constitutional discretion by the governor under Article 200 justiciable? Now everything is related to the governor and Article 200. Is Article 361 an absolute bar to judicial review in relation to actions of the governor under Article 200? Now you should know again what is Article 361. I know you are very smart people, you might know or not, but just for the sake, Article 361, I have given it over here. Article 361 of the Indian Constitution grants the President and the state governors immunity from the court proceedings for acts performed in their official capacity. Okay? And the term of office, just read it. Okay? In simple, whatever they do in their official capacity, they have been granted immunity. But if this is there, then how can there be judicial review? That is the question. Now, in the absence of a constitutional prescribed time, the main question was points which are not mentioned in the Constitution. In the absence of a constitutionally prescribed time limit and the manner of exercise of powers by the governor, can timeline be imposed? Can the Supreme Court impose timelines be imposed and the manner of exercise be prescribed through judicial orders for the purpose of exercise of all powers under Article 200? It will take a lot of time. Just read through it. You will understand the main tussle, what is going on. With these 14 points. Now what happened next? Next is our president went to the Supreme Court, asking the 14 questions. So what did the Supreme Court do? Supreme Court had established a constitutional bench. Earlier there was what? A divisional bench of 2 judges, 2 Supreme Court judges. Now there is a constitutional bench. The difference is whenever there is a question of constitution, whether there is a question of law into question, then a constitutional bench is been set up, and the criteria is it has to have 5 judges minimum. Then only it will be called a constitutional bench, and then only it can think and ponder upon the questions of the constitution. So these were the 5 judges: Justice P.S. Narasimha, Justice Suryakant, Justice B.R. Gavai, Justice Vikram Seth, and Justice A.R. Chandurkar. And she is a president, incumbent president. Okay. She gave the questions. Now these 5 judges thought upon it, and now this is the background, which most of the media houses or most of the newspapers are not covering. What happened in the background? It didn't happen in one day affair. The questions went to the judges, and what they said, what they asked other states also to give their opinions. All the other states to give their opinion. Now most of the other states also gave their inputs, mostly opposition related states, because most of this bill and act tussle is going on states which are in contradictory to the ruling regime, to the ruling central regime. States like Kerala, Tamil Nadu, West Bengal, Karnataka, they all gave their input themselves. Now who were the 2 lawyers, prosecutors? They are the men who debate. He is Tushar Mehta sir. He is the present Solicitor General and he is representing the central government, and in opposition was Harish Salve, like world renowned lawyers. Both sat on the table, both were in front of the judges and both gave their views. Now all this happened. What was the final judgment? Now see, here is the page of the final judgment. Remember Article 143 also. Using the powers of the Constitution given, using the powers of the Article 143 given in the Constitution, the President approached the Supreme Court and asked the 14 questions. See, it is a advisory role. Whatever the Supreme Court says is not binding. Remember that, it's not binding. It is in the power, very much in the power of the President to ask constitutional questions, legal questions to the Supreme Court to ask his opinion. But whatever opinion the Supreme Court gives in return is not binding. Just remember that. It was a very high stakes hearing, everyone knows that. All the central leaders were seeing it is a high stakes judgment. What the bench learned? We discussed the names also, not issue. Now, what the Supreme Court said earlier, this is earlier, what the Supreme Court said earlier, and then what is happening. Prescribed a 3-month timeline, we discussed that. Held that the governor must act forthwith or within 1 month, we discussed that. If the governor withholds assent or reserves the bill for the president's consideration, the judgment held this must be done within a month of 3, like the president has to within 3 months. give her judgment, whatever views it had, reject it, present it, pass it within 3 months. Discuss that. Now, what were the key questions? The presidential reference raises 14 questions we saw. Whether the president and the governor must follow the judicial prescribed timelines. Now, the divisional bench gave the timelines. Now, whether they must follow it, despite the constitution being silent. The whole idea is, the whole foundation of the debate is what? That the constitution is silent on it. Next is, are such executive actions justiciable before the courts prior to bill becoming a law? Like, what does the judiciary do? When a law becomes an act, after that it says, it interprets whether it's justiciable or not. But in the present context, before becoming, the Supreme Court is intervening. Is deemed assent, like if the governor is sitting for indefinite time or for a maximum time, then what happened, what the divisional bench said was that it will be deemed assent. Whether they signed it or not, it will be deemed that it has been signed by the governor, it has been passed by the governor. Is deemed assent constitutionally valid, and can SC impose procedural directions on the president or governor? Can Article 142, the Article 142 is what? It is the power of the Supreme Court to do complete justice. Can Article 142 be used to override express constitutional provisions? Can the Supreme Court say that I am doing complete justice and override constitutional provisions? Can the President's direction under Article 201 be sub judice to timelines and judicial review? Same question is being repeated in different language. Again and again. More flowery language is being used, and each and every point of the same question is being asked again. Now, all this was the questions part. Now, what is the judgment? Judgment in simple means no timelines. The Supreme Court overruled its judgment, backtracked that there will be no prescribed timelines for the governor or the president. The governor, the timelines was 1 month, and for the president was 3 months. Both were nullified, both were cancelled out. Therefore, there are no more timelines. Presidential references response highlights 5 normal article. Timelines ruling nullified. That is it. Understood? Second is, courts cannot impose time-bound mandates. All this is saying that timelines were nullified. Limited judicial review and intervention allowed. What this is saying? Courts may issue limited direction requiring governor to exercise one of the 3 constitutional options where it is prolonged, deliberate and inaction. What it says is, in the next slide we'll see it better, but for example, the Supreme Court, the judges of the Supreme Court, the judiciary itself has got powers, itself has got its responsibilities. It has to follow those also. That is what it is. It is saying that, we are not giving any timelines, we are not making you time bound, but we also have got policies, we also have got responsibilities to fulfill. If these come in contradiction to our responsibilities, then we have to act. Then it is constitutionally mandated for the judiciary to act. That is what it is saying. Governor can exercise discretion. Governor cannot withhold assent, override without returning bill. Simple? Understood? Deemed assent is said unconstitutional. Like I said earlier, deemed assent was said it will be done, but now the next ruling said that deemed assent is unconstitutional. Now I suppose this is the last slide, and caution. This is what the Supreme Court said. We also have got obligations and responsibilities. Just keep in mind, just for some thought, keep in mind that the governor and the president, keeping the constitutional powers in mind, in the same case, Supreme Court also has to follow its guidelines. It is the guardian and interpreter of what? The Constitution itself. And if things are not going along the Constitution, then the Supreme Court has to intervene, be it in the form of judicial review. So, this was a cautionary statement that you have to be within your constitutional limits. In the same manner, our responsibilities and our obligations also have to be fulfilled. Our commitment also needs to be fulfilled. That was the whole debate. Thank you.